Good afternoon, everyone. This is Richard Hackett from Boulder County Community Planning and Permitting. We are recording. You may begin.
Thanks, Rick. This is Commissioner Bloomfield. This July 20th, 2022 meeting of the Boulder Planning Commission will now come to order. Due to COVID-19 concerns, this meeting is being held virtually. Information on how to participate in the virtual meeting has been posted on the Planning Commission webpage at www.boco.org/PC. There will be an opportunity to remotely provide public comment on the dockets listed on the agenda during the respective virtual public hearing portions for each item. I'll provide instructions about that when we get to each docket on the agenda. We'll do a roll call. Mark Bloomfield here, Sam Fitch.
Here.
Ann Goldfarb.
Here.
Sam Libby.
Here.
Gavin McMillan.
Here.
David Shue.
Here.
Connor Kennedy.
Here.
Chris Whitney.
Here.
And Leishan Gargano.
Here.
Okay, just a reminder for the planning commissioners, please identify yourself before speaking and speak slowly and clearly. All votes will be roll call votes. Please keep your video on when possible during the hearing. Please remain on mute until you are ready to speak. When you begin speaking, please identify yourself as a planning commissioner, such as this is Planning Commissioner Ann Goldfarb. It may help to keep your participant list open in Zoom so that you can see who's speaking. The person who is speaking will be bolded. Okay, so the first agenda item is the minutes. Does anybody have any comments on the minutes? I apologize, I'm flipping back and forth between screens here. If I don't hear any comments, does anybody have a motion to approve?
Move to approve. This is Commissioner Goldfarb.
Second.
Commissioner Whitney, second.
Okay. We'll go ahead and do a roll call vote. Mark Bloomfield, aye. Sam Fitch.
Aye.
Ann Goldfarb.
Aye.
Sam Libby.
Aye.
Gavin McMillan. Gavin, I didn't hear you there.
Oh, okay. Sorry. Aye. You hear that? Okay.
Yeah, I heard that.
Good.
David Shue.
Aye.
Connor Kennedy.
Aye.
Chris Whitney.
Aye.
And Leishan Gargano.
Aye.
Okay, it passes unanimously. Does staff have any updates for us?
Good afternoon, Commissioner Bloomfield. Kim Sanchez from Boulder County Community Planning and Permitting. We do not have any staff updates for you today. Thanks.
Okay. Thanks, Kim. Okay, we are on to agenda items. We have one agenda item scheduled for today's Planning Commission meeting. At this time, I'll take the opportunity to explain the public hearing process. There will be opportunity to provide public comment remotely on the subject items for which we have specified. We will take public testimony during the public hearing portions for each item. The order of presentation will be to hear from staff first, next the applicant, and then we'll move to accepting public comment from any individuals who wish to speak. Some people may have signed up in advance and we will call on you first. If you did not sign up for public comment, you may sign up in the chat. Please direct your comments to the board. The chair will direct any questions that arise during the hearing to the appropriate party. Once we have heard all testimony, the public hearing will be closed. Planning Commission will then discuss the application and vote to take action. All members of the public will have a chance to speak, even if you didn't sign up from the PC homepage beforehand. Once those who signed up in advance have spoken, I will call for any additional members of the public to speak. If you joined by computer, you can sign up by submitting your first name, last name, address, and the docket number in the chat box to the right. As each person who is joined by computer and Signed up to speak is unmuted. Zoom will adjust your participant status so that you can speak and be seen via video. Once you're finished speaking, Zoom will place you back in the room as an attendee. If you dialed into the meeting via phone, please raise your hand by pressing *9, and we will unmute you when we call on you to provide comment. When it is your turn, the system will request that you unmute yourself with *6. Once you are unmuted, either via computer or phone, if you have called in, please state your name and address for the record before providing comment. Each speaker will be allotted 3 minutes to speak. The timer will beep at the end of your speaking time. Time can be pulled at 3 minutes per person for a maximum of 10 minutes. You'll need to provide the names and addresses of the other people that you're pooling with, and anyone who is pooling time together will need to be in attendance of the virtual hearing. Please do not submit comments or questions in the chat box during the meeting. The chat box is for speaker sign up only. Please remain on mute when possible. The moderators will mute you if we see that your connection is the source of background noise. Members of the public will be unable to share their screens during the public comment. Applicants, please have your presentations pulled up and ready to go. I will announce when we are ready for you to present, and at that time you can share your screen. Okay. Pull this up. Okay. Oops. So this is a public hearing for docket item SD-22- oh, sorry, that's the wrong one. Looking at the minutes and not the, here we go. This is the public hearing for docket item DC-22-0003, Article 19, Marshall Fire, Accessory Dwelling Land Use Code Text Amendments. We will now hear from staff. Hannah, if you could go ahead and present the staff report.
Thank you, Commissioners. Good afternoon. I am Hannah Hipley with the Community Planning and Permitting Department, here to present DC 22-0003. The Marshall.
Hannah, I'm sorry, I'm having kind of a hard time hearing you. Are there folks also? Check
Yes.
which microphone you're using, Hannah. Your Zoom might be the wrong mic.
Yeah, I can't understand what she's saying either, Sam.
Give me a minute. Is this any better?
I think so.
Okay, great. I see some head
Yes, that's better. Thanks.
up. Okay, thank you. Sorry about that. Let me go ahead and share again. Okay, so again, I am Hannah Hipley. I'm with Boulder County Community Planning and Permitting, the staff planner presenting docket DC 22-0003, the Marshall Fire Recovery Accessory Dwelling. These are text amendments proposed to Article 19-500 and Article 4 of the Boulder County Land Use Code to provide an allowance for an accessory dwelling to be built as part of Marshall Fire Recovery. Currently, the Boulder County Land Use Code includes 3 types of accessory dwelling options in unincorporated Boulder County. All of these options are for specific uses, and they all require a limited impact special review for approval. The Boulder County Comprehensive Plan continues to direct new growth and development to urban areas where a full range of urban services is available. We're a rural and diverse county with minimal services that support development. For example, public water and sewer are not available in most areas. Boulder County Comprehensive Plan policies, which have allowed us to reduce urban sprawl, locate growth in appropriate areas and preserve and protect environmental resources and open space has also led to limited allowances for accessory dwellings in the land use code. In 2019, the housing element of the comprehensive plan was revised and adopted to include new policies, which provide support for the county reviewing options and potentially allowing more opportunities for accessory dwellings in ways that can fit within the context of the whole comprehensive plan and meet the land use code criteria for amending the code. And you can see on this slide, I've highlighted some of those policies from the housing element that are relatively new to the comprehensive plan. And down below are the criteria for examining a text amendment. On May 8th, 2022, the Board of County Commissioners authorized this text amendment to explore the possibility of expanding the allowance of accessory dwellings in the county. And this update is being conducted in 2 phases. We are looking at phase 1 today, which is an update of Article 19-500, which expands the use of accessory dwellings for homeowners who lost their homes in the Marshall fires. This expedited timeline for phase 1 is in recognition of the needs of fire survivors who are currently in the rebuilding process and need to make immediate housing design and financing decisions. The proposed text amendment is intended to support rebuilding for those most impacted by the Marshall Fire and to provide predictability in outcomes while still implementing the county's comprehensive plan and essential land use principles. Phase 2, which would be an update of the land use code and applicable countywide, is anticipated to closely follow the completion of phase 1. Currently, as we saw before, there are 3 types of accessory dwellings allowed in the land use code and included in our definitions of accessory dwelling. What the first change we propose in the text amendment is to add a disaster recovery unit as a 4th type of accessory dwelling. Including this as a defined use described by the code as, or technical necessity, which then allows us to develop regulations related to this use. The text amendment proposes to add subsection F2 to the existing language in Article 19-500. No other changes to the article are proposed. So section F is the section in Article 19 that's the allowances and requirements for eligible structures and floor areas. The proposal adds, pardon me, section 2 and establishes the requirements for the disaster recovery unit. All of the existing requirements of Article 19-500 remain applicable, and consideration of the disaster recovery unit would be in addition to application of the existing section. Changes to the existing code are shown through underlining in your Exhibit A that was provided to you in the packet. And those are the only changes we're discussing here today. So on this slide, sorry, this is a zoomed out view of all the text amendment. We really are just focused on this underlined part today, not touching the rest of Article 19-500. So moving forward, I'm gonna just hone in on the section F2 that is new. The first section here establishes that an accessory dwelling is allowed to be constructed on properties where the primary residence was destroyed by the fire. The applicability of the regulations reflect the stated intent of phase 1 and the nature of the process undertaken to develop the regulations. The next section goes into the various requirements that are applicable to all disaster recovery units. The proposal does establish a 700 square foot limit for the accessory dwelling. And this provides a clear and simple approach to addressing the size of the dwelling unit. Since multifamily dwellings are not permitted in the relevant zone districts. Limiting the accessory dwelling size will ensure the text amendment is not contrary to the existing zoning regulations. In addition, the requirements state that the floor area shall be considered residential floor area and shall fit within the size allowance provided in F1A above. The code was amended in 2008 to establish the amount of residential floor area presumed to be compatible in a neighborhood. This presumption allowed for an acceptable rate of increase in the development on property within Boulder County and was part of the implementation of the sustainability element of the Boulder County Comprehensive Plan. Including the accessory dwelling and the allowable amount of residential floor area on a parcel upholds the intent and purpose of the code and the comp plan, and again ensures accessory dwellings will fit within the character of the neighborhood, and also ensures that the new allowance for accessory dwelling units does not deviate significantly from what the code already allows. I just also want to note that this reference F1A above is a reference related to the size of redevelopment under Article 19, and this does allow for an increase in residential floor area under Article 19. The requirements on this page speak to the limitation of primary dwellings, or as the limitation of short-term rentals on the property. It does require the accessory dwelling to use the same access point and driveway as the principal residence, and requires one on-site parking space to be provided for the accessory dwelling. Support for accessory dwellings in the comp plan is found in the housing element, as I pointed out, as one way to provide additional housing for residents to address the lack of available affordable housing in the community. The housing element of the comprehensive plan supports addressing the lack of affordable housing in the community, and allowing these smaller units furthers this goal. However, if these units are converted to short-term rentals, they no longer serve those immediate housing needs of the community. Not allowing the principal single-family dwelling to be used as a short-term rental helps ensure that properties where the intensity of the use is increased due to an initial dwelling unit are not further intensified by short-term rental units, and thus help maintain neighborhood character. The requirement for an accessory dwelling to use the same access point and driveway as the principal use also help maintains that single-family neighborhood character. So we don't have multiple driveways to a property. And it also allows the traffic impacts of the new dwelling unit to remain on the site where the use is, rather than be pushed to other locations. Additionally, the development of new driveways can often have significant impacts on the land and environmental resources. So if we're reusing the same driveway, we minimize this potential for impacts, and really reduces the need for a land use review process to analyze those impacts. For the currently proposed size of 700 square feet, staff is recommending that one parking space be required on site. An additional dwelling unit in the rural areas of the county is likely to generate additional parking needs. And the impact of these additional needs, again, should be felt and minimized and mitigated within the parcel generating that need, rather than, again, pushing kind of those impacts to adjacent property owners or the neighborhood as a whole. So these next two requirements really speak to the provision of essential services, water service and sanitary sewer service, requiring that at the time of building permit, adequate water and adequate sanitary sewer service are demonstrated at the time of building permit submittal. An additional dwelling unit is going to generate the need for additional water and sanitary sewer services to a property. But since the county is not a utility provider, the entity that does provide or regulate these services must permit the development of an additional dwelling unit on a property. And again, these sections just require that this service availability is provided and demonstrated at the time that someone applies for a permit for an accessory dwelling. These last three items are a little bit more technical in nature. The first one is that the principal single family dwelling and the accessory dwelling shall remain in common ownership. So the intent here is that accessory dwellings are not intended to drive the creation of new building lots or really create separate units of density. Nor are these regulations really drafted in a way that would support condominium ownership. Condominium ownership is defined in the land use code. In instances where the accessory dwelling is constructed prior to the principal dwelling, a complete building permit application for the principal dwelling must be submitted by March 29th, 2027. After this date, the accessory dwelling will be considered the principal dwelling in use on the property. And a one-time extension of up to a year may be granted by the director if good cause is demonstrated. Again, part of what we're doing here is just clarifying that an accessory dwelling may be constructed prior to the principal use. This is not typically how things work in the code. There usually needs to be an established principal use in order to build something accessory to that. But we do know that folks might want to build this unit to live in while they build the principal dwelling. So this provides for that. However, over time, if a principal dwelling is not constructed or may never be constructed, the structure that is on there, the dwelling that's on there, would become the principal. And we're using the March 29th, 2027 date here because that is the time when this section, Article 19-500, sunsets as a whole. After that date, the property would be subject to the standard requirements and allowances in the code at that time. Four types of disaster recovery units have been described by the amendment, and this reflects the various permutations of accessory dwellings that could be developed. And since these various types have the potential to have different kind of levels of impacts and different degree of impacts, the additional provisions have been developed for each type. So those types with the potential to have more impacts include specific limitations or may require additional review. And those with less potential to have impacts have fewer requirements. So detached units are defined here on this slide, which is a standalone accessory dwelling separate from the principal single family dwelling or any other accessory structures. Detached units have the potential to create new impacts, as generally these aren't replacement structures. They're new structures in the landscape, and they carry a substantial potential for impacts. To mitigate these potential impacts, these requirements have been established, which limit the height and encourage the unit to be clustered with the development that pre-existed the fire. So this is the height limit established here is 20 feet. And the clustering requires that the structure be located. If the structure is located more than 50 feet from the footprint of the single family dwelling destroyed by the fire, site plan review waiver shall be required for the detached accessory dwelling. So if the new structure is located within 50 feet of the footprint of the pre-existing house, no land use review process is required. However, that location doesn't work for somebody or they want to consider a different location, site plan review waiver is an option for them, and we would look at that structure's location and its impacts through that process. The director's written determination under the site plan review waiver may be directly appealed to the Board of County Commissioners, and we include this language here so that folks can go directly to an appeal process rather than what our code currently sets up for site plan review waiver, which is to have folks go through a full site plan review and then appeal that outcome. So this expedites that a bit. So the next type is a unit that's attached to an accessory structure by sharing either a wall or a floor with a detached accessory structure. So this might be a detached garage with kind of a unit on top or a unit to the side. It could be attached to a workshop or really any other type of detached accessory structure. And these can really occur in two ways. Somebody might have had a detached accessory structure that was destroyed by the fire, and they're rebuilding that structure in addition to the accessory dwelling, or they may be building a new accessory structure that they didn't have before. And so the location requirements reflect those differences. If you're rebuilding a detached accessory structure, compliance with the location requirements that we've established previously in Article 19 are what is required. However, if the structure is new, then just as like with the detached type, it is encouraged to cluster with the previous development, but the site plan review waiver is an option, and that appeal, that more expedited appeal process is allowed. The third type is when the accessory dwelling is attached to the principal structure. So this is when it's designed as part of the principal single family dwelling. It shares a wall or a floor. So again, this might be, a lower level unit. It might be attached to the side, but it really just needs to share one of those components. So no additional provisions are proposed here outside the clarification that the requirements for rebuilding the original structure continue to apply. And these aren't necessary since the existing sections of Article 19 have established parameters for rebuilding the principal structure. And this unit is anticipated to have little potential for new or different impacts that have not already been considered when adopting Article 19-500. The last type we have is for when property owners have existing legal floor area that was not destroyed by the fire, which they wish to convert to use as a disaster recovery unit. So a land use review process is not considered to be necessary here, as the impacts of the development have already occurred and are understood by the community. We anticipate that some of these existing structures might not fit within the size limitations established by this text amendment process, but it is the intent that these structures be permitted to be converted to accessory dwellings. So B here provides that flexibility to allow the reasonable use of existing structures for this purpose. Outreach and engagement for this process included community meetings that we held prior to drafting the regulations. Polling at the community meeting was done, and these responses are included in Exhibit C. An online survey was also available from May 25th to June 1st, and these results are included in your packet as Exhibit D. There was a referral and public comment period from June 16th to June 28th, with written public comments attached as Exhibit E and the agency referral responses included as Exhibit F. So the revisions that were posted in the Planning Commission packet reflected input through the referral and public comment period, as well as the community meetings in the survey. The Planning Commission packet was posted for review and comment on July 13th, and we did receive a couple of written comments after this time that I think were passed along to Planning Commission. The text amendment criteria that we examine when making a staff recommendation is that the existing text is in need of amendment, that the amendment is not contrary to the intent and purpose of the code, and the amendment is in accordance with the Boulder County Comprehensive Plan. This text is in need of amendment if we are to allow accessory dwellings outside of the 3 ways that already exist in the code. A text amendment is necessary. The amendment is not contrary to the intent and purpose of the code. The proposed text amendment seeks to support rebuilding efforts while mitigating the land use impacts of accessory dwellings. And by establishing appropriate parameters, it is consistent with the land use code. So as proposed, the text amendment does conform to the intent and purpose of the code. The proposed language is rather moderate, reflecting sort of an expedited text amendment process, the intent to maintain a simple and streamlined review process for those rebuilding, and the intent that the regulations adopted within Article 19 do not establish parameters that might not be acceptable in the context of a county-wide amendment. As proposed, the text amendment does not make changes to the code that would alter the code's consistency with the goals and policies of the comprehensive plan. And the proposed text supports the identified housing element goals while remaining in accordance with the broader policies. Pardon me. Staff does recommend that the Planning Commission approve and recommend to the Board of County Commissioners approval of Docket DC 220003, Article 19, Marshall Fire Accessory Dwelling Land Use Code Text Amendment. And I've included a recommended motion for you here if needed. That concludes my presentation at this time. I'm happy to take any questions.
Thanks, Hannah. Do we have any questions for Hannah at this time? Commissioners?
I have one. This is Commissioner Gargano. I just maybe it's me restating and making sure I understand. So looking at the survey feedback, it looked like a lot of people wanted more square footage options, but it sounds like we feel like the 700 max is more in line with our current code. So that's why even though the survey, most people said up to 1,000, we stayed with 700. Is that?
It is. It's a place where we think the use remains consistent with the code, in line with sort of the other sizes we have for the family care unit in the code. It remains an accessory level and really can fit into these areas without generating a lot more impact.
Okay. And then 1,000 starts to feel like multifamily.
You know, that's the concern, is these do need to stay accessory and not turn into sort of, you know, 2 full dwellings on a property.
Right. Okay. Thanks.
This is Commissioner Goldfarb. To follow up on Commissioner Gargano's question, I'm looking at that 700 square foot limit and wondering exactly what the purpose of adding these provisions is, because if it's in fact to help people impacted by the fire with the idea that they would live in this unit while they were building their new unit, 700 square feet doesn't seem like enough, assuming that you have a family. So am I misunderstanding the purpose of this?
Well, I think there are multiple purposes. I think there are other, the accessory dwelling is something we think will remain on the property long-term into perpetuity. The Article 19-500 includes some other options for temporary housing that we think could be used in combination with this to address those families that might have a family that they're trying to house on site temporarily. But what we're really talking about here today is what remains long-term after that.
Hannah, this is Commissioner Bloomfield. Can you give an example of what you mean by that? Like how they would do an ADU in combination with something else if they needed something bigger?
Well, the temporary housing is already an option that's in Article 19-500. So if they were building something that was larger and then only 700 square feet of it remained as an accessory dwelling over the long run, the Article 19-500 also allows RVs to be used as housing. So some combination of, a certain size structure in the RVs could also be an option for folks.
Okay, thank you. Do we have any other questions for staff?
I do. This is, oh, go ahead.
Thanks. This is Commissioner Shu. I guess I wanted to get clarification on multifamily units. It seems to me that's a specific definition of a unit, not necessarily that there are multiple families on a piece of property. Is that correct?
The land use code defines a multifamily in a specific way, and it's off the top of my head, structures designed to house multiple families. I mean, just to simplify what's in the text of the land use code, which is why when we say is 700 the right number, to make sure that we're not multifamily, there's not a numerical definition in the code for what's multifamily versus, what's single family with an accessory dwelling.
Okay, so it sounds like multifamily describes the structure. So I think some of the comments, public comments, were that an ADU would help with another income stream, and there's an option for long-term rentals. So there would still be the use to rent out the ADU to a second family. Is that correct?
Yes, you make a good point. When I responded to the previous question about the purpose, having the ADU contribute to folks getting back on site temporarily was only one of the purposes that we heard from the community for these accessory dwellings. Folks point to, the need to have family age in place, or maybe they have young people who can't find affordable housing. They might need the caretaker unit. They might want to rent the unit out long term to help them recoup some of the losses that they experienced due to the fire. So there is that range of purpose, and it is intended that we do think these units would be available for rent to the community.
Okay, thank you.
This is Commissioner Kennedy. I have a question on the same subject of kind of square foot limitations. And just to clarify, my understanding is that this decision and the wording and amendment that we'd be deciding today reflects purely on the disaster relief, fire relief regulations, and that phase 2 would focus more on a broader county-wide approach to the ADUs. So Hannah, I was just wanted to clarify that in theory, because obviously some of the concern with ADUs is, density of housing, and some of our citizens have concerns about that. But in theory, this amendment could say something like limitations up to 1,000 square feet for disaster relief specific use, but phase 2 of an ADU policy could in theory have a smaller limitation of, say, 700 square feet. Is that possible?
It's possible that things could shake out that way. It becomes a little bit complicated then for those folks who ended up building a disaster accessory unit, which can be constructed during this time constrained period after a disaster. But then is no longer, after the disaster regulations sunset, it doesn't conform then to what was what might be permitted in the land use code. So folks might end up with a non-conforming situation. We did, I think the proposal is, like I said, it's a relatively moderate proposal, kind of intended to hopefully allow these two phases to sync up, so we don't end up with homeowners who maybe don't meet their zoning regulations after the fire regulations cease to be implemented.
Yeah, I think that makes sense. And I think ideally having the two phases with a really similar, if not the same set of regulations and maximum specifications makes a lot of sense. But I just wanted to clarify, since we are kind of talking about it in a two-phase approach here. Thanks, Hannah.
It's good, Commissioner Libby, to keep on that question. As I understand that, Hannah, that means that people are basically putting trust that phase 2 will happen in the county and that something will be approved that will allow these by right after 5 years. Is that correct? Because otherwise they will become out of use. Right?
They would become legally non-conforming uses.
Okay. Okay. So they would be allowed to continue using them because they were conforming when they were built. Okay. I had a few more questions. The name disaster recovery unit, I think, is nice. It's generic, but the text in the amendment actually refers very specifically to the Marshall Fire. Is there a need to have that specific bounds around it and say this is only for the Marshall Fire, or if there was another fire a year from now, God forbid, would we have to be recreating this or amending it to allow that in that area?
Well, the language is specific to the Marshall Fire because we're only modifying and updating Article 19-500, which is specific to the Marshall Fire. Should we have a future disaster where we thought the disaster recovery unit was appropriate, we could then use that same definition in that kind of next Article 19. But for now, this really is related to the Marshall Fire section of Article 19.
Okay.
And this is Commissioner Gargano. That whole section expires in March of 2027. So the whole thing expires and we would have to write a new one for regardless, right? Like it.
But I guess we have some good precedent at that point of something that people thought was a good idea at this time. So that's good. I had a couple other targeted questions about the requirements section. I think it was A.2. There were a lot of letters and numbers in that. There was a line in there around disallowing short-term rentals, vacation rentals, et cetera. Is that requirement specific to disaster recovery units, or that should be applied to all ADUs?
At this point in time, the only modifications we're making really are to Article 19-500. So it doesn't change any other sections of the code at this point in time.
Okay. Can you go to just put that up on screen? It might be the next slide. It was the one that mentioned the limitation on vacation rentals, et cetera. So I guess reading this, it seems like it's talking about more than it is. Maybe it should say with a disaster unit or something. Is this accessory dwelling as part of that?
Yeah, these are all requirements that are a subset to that disaster recovery unit section. So
okay, so the intent of this is to disallow several types of rental activity, but allow, like you said, in the future, it to be rented to somebody in the community, potentially.
correct.
Okay. On the parking topic, is the intent that they would be adding a space for the ADU, or there must be at least one existing space?
The intent is there would be an additional one parking space for the accessory dwelling.
No matter how much they already have, they have to add one additional one?
Well, I mean, the parking requirements for a single family dwelling, if those are met and exceeded, then they may not actually need to add one. That might depend from property to property, but the accessory dwelling must have one for it.
Okay,
Whether
just
that
as
means
worded,
they need
yeah.
more or not, I think that's going to be a site-specific call.
Okay, as long as that's the intent. It sounds to me like they have to add one, and then what you said I agree with, but that's not how it read to me. And then the last question was around the 50-foot distance from the original property or the original structure. Is that intended to be entirely within 50 feet or touching 50 feet? It seems to me that's a little bit small. If you're doing a lot of heavy construction of a whole property with equipment, people moving around, being 30 feet away within 50 feet of your house being rebuilt is not ideal. I understand the reasoning behind wanting to keep it clustered, but is that entirely within, or just must have some piece of the ADU that is within 50 feet?
So the language is if it's more than 50 feet. So how I would sort of imagine this playing out is, we know what the footprints are, the pre-existing dwellings. Folks have been locating those on site plans and things for us. So it would sort of just be a buffer of 50 feet from that. And then if they're outside that buffer, a site plan review waiver would be required.
If the entirety of the structure is, or if any of the structure is?
I think if any part of the structure is, so the structure would need to be located within that buffer, but I could see why that's not clear from how this is drafted.
Okay. And the follow-on was there's a, great, we have an option for a waiver. What is that process like for the site plan review waiver? I don't know that offhand. Is that a relatively administrative director approval, or is that a planning commission or adjusters?
No, that's an administrative approval
Okay.
done at the staff level. Typically that time period is about 2 weeks. So it's
Okay.
sort of our kind of lowest, easiest level of review process that we have in the county.
Okay, thank you. That's all my questions, I think.
No.
Any other questions for staff?
This is Commissioner Goldfarb. This is related to this Marshall Fire issue, but I guess more related to phase 2, where we're talking about allowing ADUs for any property in the county. And I'm just wondering if there's been any thought to or discussion about what this increase in density will do to the roads in these areas. Because as things stand now, I live in Spanish Hills and our roads are a mess. And they're getting worse with all the construction traffic that's coming through. And if we're building potentially 2 structures on lots, or if people who are already living in the county in these areas decide to build another structure on the property, you've got more density, you've got more traffic. What's the thought as to road maintenance, and has there been any discussion about that?
Not in depth at this point in time. This particular phase 1 was very focused. It did not include an in-depth analysis of potential land use impacts of this happening on a larger level, of this happening on roads. Your points about kind of traffic and trips and that sort of thing also ties into kind of the conversation about size. The bigger the house, the more people that live in it, the more cars there are coming and going. So, all of the regulations that we've proposed sort of fit together to hopefully allow these things to be constructed by folks who might need them and really needed to know if they could do them within an expedited time frame. I think as we move into phase 1, because there is quite a bit of detailed analysis that should happen regarding transportation and a variety of other issues, we know that process is going to take significantly longer than the few months that we've taken to get to this point with phase 1. Does that answer your question?
Yes, thank you.
Hannah, this is Commissioner Bloomfield. Can you just state what the intended schedule for phase 2 is?
I do not have that. Our intention is that it closely follow this, but I do not have a timeline for it at this point in time.
Okay, thank you. we have any other questions for Hannah?
Yes,
Oh, sorry, go ahead, Commissioner.
Thanks. This is Commissioner McMillan. Hannah, thanks for the presentation. You suggest an alternative approach that was discussed. It says an accessory dwelling shall not exceed 30% of the size of the residential floor area of the principal single family dwelling, just as another way of approaching this. And, you know, I do think that's an interesting idea. And my question is, have you had any thought about how that might work, given that in most cases, the single family dwelling in this case wouldn't exist? Or has that not been thoroughly vetted yet as to how that would work?
Well, if someone were building sort of the accessory dwelling first or converting floor area, they would know at that point in time what the ultimate sort of allowance under Article 19 they can get for size, and we could use that as a parameter. You know, if they're building it as attached to the principal residence, there's less of an issue. You know, it isn't perfect, especially when folks are building the accessory first. So
Yeah, I think it's interesting because then when they may come back and when they build their principal structure, you know, essentially have to build a structure of a certain size. Just seems kind of backwards. But I do think, well, I'll save my comment for later, but I think it's interesting approach. My other question was, we specifically say that this is only for homes that have been destroyed, which I think we all know generally what that means, but let me just give you a hypothetical. If there's a home that's become uninhabitable because of smoke damage, or part of a home was destroyed, is it intended that those homes would have the same rights that come under this emergency kind of situation? Or is that destroyed term a bit gray? It seems
no, destroyed means the house was completely destroyed. We have 157 homes in the county that were destroyed by the fire. And we have a pretty good idea
okay.
of what those are.
Okay, got it. Good. I'm glad that's clear. I could see that being vague for somebody who maybe wanted to build an ADU under these, but wasn't a completely destroyed home. And then lastly, just to clarify from my knowledge, I know you answered this earlier, I apologize, but the 700 square feet number is tied specifically to an existing type of housing use, right? And I forget what the name of that housing use was.
It is what we currently have in the code for the size of a family care unit.
Family care.
Yeah.
Okay, great.
this is Commissioner Shu. Can I jump on the family care unit? So I was reading the definition of that. It seems to be that it's to be occupied by a family member, and you know, to me, it's the intent is a single family member. So I was wondering, you know, why look to, I mean, are there other comparable square footages that we can look to besides the family care unit, given that it seems more limited to a single person? And then kind of along those lines, where do 1,000 and 30% come from?
Well, we did look into those sizes a little bit. 700 square feet is roughly the size of a 1-bedroom apartment generally. So one person could live there, 2 people could live there. This doesn't dictate how many people who, you know, it just speaks to the size.
Okay, this is Commissioner Shu again. And then 1,000 and 30%, where do those numbers come from?
Well, 1,000 was sort of the break point that we heard from the community, with kind of roughly half and half wanting larger, half wanting that as a maximum. 1,000 square feet, you know, how that could be turned into a home or how many bedrooms, I guess I don't understand what you're getting at.
Yeah, I guess 1,000 is a nice round number and it was in the survey, but is there any other reason other than it's grade in base 10?
Not specifically.
Okay, and then the 30%.
Well, again, as an attempt to keep these accessory, that's a third of the development on the parcel. Sort of the larger you get, sort of less accessory and the more equal to the primary use it gets.
Okay. Okay. Thanks. Thanks for letting me jump in.
Yeah, of course. I mean, none of these are magic numbers.
This is Commissioner Fitch, and I want to go back to the question of damaged and destroyed. It says on page 13 of 115 that these provisions pertain to structures destroyed or damaged in the Marshall Fire. And the question really is, what's the process that determines if the house is completely burned down and gets demolished in the cleanup process? That's easy. But not everything is a sort of binary choice there. So how much damage do you have to do before you call it destroyed? Does it have to be uninhabitable? And who decides if you've got 2 walls, 3 walls left, is that not destroyed?
Commissioner Fitch, I think I understand the question. Damage assessment is done immediately following a disaster, and I just saw Kim turn her camera on. She might be able to help here. Did you want to jump in?
You were right on the track, Hannah. I'm just here to support if you need to.
So it's done by folks that go out into the field. They examine every property, and there's sort of a set of parameters that they use to make that evaluation.
Yeah, this is Kim Sanchez. I would just add that immediately following the disaster, we performed damage assessment inspections. And so those are the numbers that get reported to the state and to FEMA for disaster declarations and funding and all of those things. So we had inspector teams that surveyed we actually had several teams that looked at Superior, Louisville, and unincorporated Boulder County. But in unincorporated Boulder County, we were in a fire. It's a little bit more clear to be able to see what is considered destroyed versus what is damaged versus something like another disaster like a flood, where there may be some sort of subjectivity that's in there. Usually in a fire, the structure is unfortunately just gone, and you see foundation there. So I think our numbers that we have are the numbers that we've been relying on pretty reliable. We allowed people to self-report damage also and followed up on any of those. So it was a pretty comprehensive and thorough damage assessment that was done immediately after the event to get to the breakdowns that we did.
Thanks, Kim. Do we have any other questions for staff? If we don't,
I have actually one more question for staff. The requirement is that it's the primary structure was destroyed, and kind of given what I know of some of the area, especially like around Marshall, there were maybe existing non-conforming ADUs that were inhabited that may have been lost. I was curious if staff had considered like allowing disaster recovery units under this site plan review waiver process, or perhaps like an existing non-conforming ADU to be rebuilt as a ADU, even if the primary structure wasn't lost.
If the accessory dwelling was truly legally non-conforming, it can be rebuilt. It doesn't need this accessory dwelling process.
Okay, thank you.
Any other questions? go ahead and open public comment. I'll start with the procedures for public comment. All members of the public will have a chance to speak, even if you didn't sign up from the Planning Commission homepage beforehand. Once those who signed up in advance have spoken, I will call for any additional members of the public to speak. If you joined by computer, you can sign up by submitting your first name, last name, address, and the docket number in the chat box to the right. In this case, you probably don't need the docket number since it's our only docket. As each person who is joined by computer and signed up to speak is unmuted, Zoom will adjust your participant status so that you can speak and be seen via video. Once you are finished speaking, Zoom will place you back in the room as an attendee. If you dialed in to the meeting via phone, please raise your hand by pressing *9, and we will unmute you and when we call on you to provide comment. When it is your turn, the system will request that you unmute yourself with the *6. Once you are unmuted, either via computer or phone, if you have called in, please state your name and address for the record before providing comment. Each speaker will be allotted 3 minutes to speak. A timer will beep at the end of your speaking time. That would be the timer. Time can be pooled at 3 minutes per person for a maximum of 10 minutes. You will need to provide the names and addresses of the other people, up to 3 others beside yourself who are in attendance and donate their time to you. Anyone who is pooling time will need to attend the virtual hearing so that we can verify their presence as we would at an in-person hearing. Please do not submit comments or questions in the chat box during the meeting. The chat box is for speaker sign up only. Please remain on mute when possible. The moderator will mute you if we see that your connection is the source of background noise. Members of the public will be unable to share their screens during public comment, and applicants, we don't need that. Okay, so looks like our first speaker for public comment is Judy Demarest. Have we promoted Judy?
This is Andrew Goldstein, CP&P staff. She is currently being promoted.
Okay, I see her coming online here. Ms. Demarest, looks like we have you unmuted.
Okay, I think I'm okay now. Can you hear me?
Yes. Thank you.
Okay, my comment was I live at Marshall. My address is 1568 Marshall Road. And we lost, several of our neighbors too lost major buildings that were underinsured, and we want to rebuild, but we did have an ADU, but nothing on our property was permitted. But as Hannah pointed out, that we would be allowed to rebuild that even though it wasn't what is it, permitted? Conforming, I guess. Oh, I guess should keep talking. Well, my point is I think now would be the time to do it. We're going to rebuild. We lost about a $300,000 structure. It was way underinsured. And a lot of my neighbors are in the same boat where it wasn't our main dwelling. And so we would like to fix it how we want, but it would include an ADU. I'm not good at talking. Let's see. But mostly that, we're older. My husband's 79 now and not going to have much income. We're on a fixed income. If we have to go through the whole process and wait for years, we'd just like to put something up quickly. We'd like our son to be able to move back and make it work for us. Okay, I think that's all.
Thank you for your comments. Next up is David Farmer.
I didn't do very well because I changed my topic.
Sorry, this is Commissioner Organo. Mark, you're pretty quiet on my end. I don't know if that's just me.
Oh, is that true? I don't know.
Yeah, it's not great. We can hear you okay, but it's not great.
Is it changed or has it been the whole meeting?
It got quieter. It wasn't loud, but now it's really quiet.
All right, let me try disconnecting this. Is that any better?
This is Commissioner Fitch. Mark, would you speak up a little bit?
Yeah, I think
I'm having trouble hearing you.
hopefully this is better. I don't know what happened with my headset, but okay.
This is Andrew Goldstein, CPMP staff. I do not see David Farmer in the hearing. Mr. Farmer, if you're here on the phone, can you please type in *9 in order to raise your hand, and we'll unmute you then. Otherwise, can you please put something in the chat? In the meantime, we'll move on to our third speaker, which is Ellen Berry.
Okay, thanks, Andrew. Miss Berry, I see that you're in the meeting. I see you're unmuted now.
Hi, can you hear me?
Yes.
Okay, great. I didn't know if we were waiting on the other person to join. I live at 5743 Marshall Drive, which is not very far from Ms. Demarest, who spoke earlier. And I represent as part of the UBC committee when we speak with the county each month. I'm strongly in favor of having ADUs to help our community. We all live in pretty small houses, and many of our neighbors are older, and we would really like to have units that work for our adult children to stay with us, units that allow people to age in place. Here in Marshall, some of the properties were completely destroyed, but let's say only 60% of our neighborhood's completely destroyed and the other 40% is damaged. We would like to see that all the damaged properties from this FEMA disaster could build ADUs and not just the ones that were completely destroyed. Because while the neighborhood's full of construction and people rebuilding barns and other accessory structures, it would just be nice if they could go ahead and build their ADUs at that time rather than having to go through a separate process and be doing construction in our neighborhood at a separate time. And the other thing is, for an ADU that really allows aging in place, we'd like to have it be slightly larger square footage so that adult children or someone who has a child could be able to be there. There's not very many children in our neighborhood, and our school's even in danger of closing because it's under enrolled. So we'd like to have a little bit more square footage, closer to that 1,000 square feet number, so that we could have multi-generational living, so that adult children can take care of aging parents, whether it's my older parents moving in or my daughter taking care of me as I age. One of the other concerns that we have is about water, allowable water being allowed, because most of us are on cisterns. And how is that going to be measured in terms of how much water you're supposed to have to support 2 dwellings? Or is it just supporting 1 person because 700 square feet is intending to be a single person? So that's a lot of my questions. I hope that makes sense to everyone. Thank you.
Thank you. Let's see. Next up is Janet Andrews. Looks like I see James Andrews, and I think I saw that.
This is Andrew Goldstein, CPMP staff. I believe we have James and Janet Andrews here who live together, and Janet will be speaking for both of them, pooling their time.
Okay, great.
Okay, yes, they can see you.
All right, there we are. Okay, thank you for allowing us to speak. I'm going to read what I wrote about a month ago to you all. It's Janet and Jim Andrews. Our address was 1025 Paragon Drive in unincorporated Boulder County. We live next door to our daughter and her family, and we're addressing this as an ADU, hopefully for intergenerational care as we age. Part of the Boulder County Comprehensive Plan housing policies state that the county is interested in, there is a connection between individuals having a safe, affordable housing and their physical and mental health. And I am concerned. I think the county's goal to first address the needs of the Marshall Fire survivors is commendable. But in fact, the proposed 700 square foot land use code limitation regarding the ADUs does not meet the above criteria for physical and mental health well-being. A minimum of 1,000 square feet, which would be comparable to a 2-bedroom apartment, is preferable, and to 700 square feet, and should be allowed. But most importantly, I want to emphasize, I think consideration should be given to the lot size. Well-designed attached or detached ADUs should be considered on an individual lot by lot basis, and with site plan review expedited for the Marshall Fire survivors. So again, my emphasis would like to be on individual lot by lot consideration. Thank you.
Okay, thank you, Ms. Andrews, for that comment. Looks like next up we have Tom Berghoff, which I see there, Tom.
Great, thanks for the time. So Tom Berghoff, 7444 Empire Drive in Spanish Hills. I've actually been serving as kind of the ADU focal point for the unincorporated Boulder County Marshall Fire rebuild team. So we had worked with Dale Case, Director of Planning and Permitting, and he'd asked us to put together some feedback collectively on this thing, and wanted to share a little bit of that with you, as well as kind of the prevailing sentiment of the unincorporated Boulder County team. So a couple of points. One is, when we did the original surveys, the surveys that were done as part of the citizen outreach and engagement process, the highest band at which somebody could express a preference for square footage was 1,000 feet. And I believe it was 52% of the people who had responded said, yeah, we'd like to do 1,000 square feet. However, I think that's understating the case. When we went back out and collected, again, as part of the outreach and engagement process, there were 23 respondents to that took the time to write in written form, 16 of whom specifically referenced going beyond the 16 of the 23 going beyond the 1,000 square foot limitation. And quite literally every single person that responded on the subject of height said that the 20 foot limit was probably not conducive to doing adequate second floor. And recall that that survey actually said that 82%, I think, of the people were supportive of doing second floor units. And I think of the 5 people that had any opinion at all on the 50-foot limitation from the house, those people all said it becomes an artificial limitation. Recall that almost all these units are either in Marshall or in Spanish Hills. They're on larger lots. Many of them have got ditches, wellheads, septic fields, and the like that in many cases won't enable somebody to logically build within 50 feet of the principal residence. We're not disputing the single access or anything of that nature, but that has become a problem. And then just a couple other points that were related to some of the feedback on the damaged and destroyed portion of this. We've got people who are smoked out of their houses, so the house looks like it's intact from the street, but will not be able to re-inhabit those houses for upwards of 2 years because of the extent of the damage, the bureaucracy of actually going through the insurance process. Most of that rebuild work has not even commenced yet. So we do have a number of our residents that are interested in building an ADU literally so they can reoccupy their property, even though they didn't lose their house. So just wanted to make sure that we made that clarification. Beyond that, I'll yield time back to anybody else that needs it.
All right, thank you, Mr. Berghoff. Next up, we have Tabor Ward.
This is Andrew Goldstein, CPNP staff. I don't see Mr. Ward here in the hearing. Mr. Ward, if you are here, please type in the chat or press *9 to raise your hand, and I will promote you. In the meantime, our next speaker is Steve Bouchon. I've promoted you for this part of the hearing.
Okay, can you hear me?
Yes.
Okay, great. Okay, hey, I'm Steve Bouchon. I'm here today on behalf of the Davidson Ditch and Reservoir Company. I understand this hearing is really about.
Say your address for the record, please.
Yes, it's 1525 Spruce is my law office of Bouchon and Holloman.
Okay.
And I understand this hearing is really about section F2. And our concerns really lie in the issuance of the building permits, which is section F1. But I do think it's important for the Planning Commission to hear these concerns. And that's because the Davidson Ditch and Reservoir Company is a nonprofit ditch company that maintains and operates a large historic irrigation ditch that also provides municipal water supplies. Its shareholders, its largest shareholders include Lafayette, Louisville, Boulder County, and the city of Boulder. And the ditch is not a small ditch, 8 to 10 feet at the bottom of the ditch, and it gets wider at the top. And then you have the ditch embankment coming down. So it takes up a fairly large, significant area. It's also over 20 miles long. And the Davidson, pursuant to Colorado law, has a easement that's considered the dominant estate associated with that ditch. And what that really means, it can use its ditch easement to access, operate, maintain, repair, and replace the ditch in whatever way is reasonable and necessary under Colorado law. And that really prevents the underlying landowners from doing anything that would impact that utility of the ditch easement. And the way the case law has come out is that in order to encroach upon a ditch easement or modify it, you need to have the consent of the ditch company. That's what the Colorado Supreme Court says. Or you have to go to court and get a declaratory order. And the reason I bring all of this up, the Davidson presumes a 50-foot setback from the center of the ditch. That's what the land use code has always said too. Now, on a site-specific basis, there can be places where they may need more to move around with equipment. Some places they can get away with less. But the real reason I'm here today on this particular change is that the Davidson ditch does run through the area that got burned by the Marshall Fire. And the board is very concerned for those people who lost their homes and structures. We've passed a resolution to be sure we have an expedited process available to them. We passed a resolution to make sure they have a discounted fee structure in order to do crossings. So we're trying to really facilitate their ability to rebuild. But our concern is that in section F1, I don't know why, but it says 20 feet. It allows a 20-foot setback from the center of the ditch. And maybe that works for small ditches. It doesn't work for a big ditch. The other thing it does is it allows the director to decide whether or not there's an impact to the ditch. And so, I mean, that raises a real concern because we don't believe the director has that legal authority. We think by statute and by case law, that really is a burden on the ditch company. And we think that usurps the ditch company's statutory obligations and its fiduciary obligations to its shareholders. So while the ditch company really does want to facilitate an expedited process, we just don't think this is a good solution. We don't want to see somebody building a structure too close.
That's your time. That's your time, Mr. Berghoff. Thank you for your comments. Or Bouchon, excuse me.
Okay.
Thank you. And Andrew, it looks like we have at least one other person that signed up in the comments.
Yes, Michael Ellis, you've been promoted and can speak if you would like. Can you please state your address for the record?
Yes, can you hear me?
Yes.
My name is Mike Ellis. I live at 1221 Red Ash Lane. And I think I can I put myself on video here.
Yep.
Red Ash is an enclave. It's zoned agriculture. The lots are between about 1 acre and 8 acres. The roads are dirt roads, some maintained, some not maintained. We're not walkable to anywhere, stores or schools or workplaces. Everybody here is on a well. Everybody here is on septic. Half the homes in our neighborhood were destroyed. The other half had significant damage. Our house was not destroyed, fortunately, but it sustained damage. Our property was severely burned. We lost a lot of trees and other stuff. If the half of the homes that were destroyed were to each add an ADU, that would increase the density and number of families in our neighborhood by 50%. And I understand the desire for housing, but most of you, if you follow politics of Boulder, you know that the city of Boulder leaders many of them are pushing for more density everywhere, and many of us live in the country. We live in rural areas because we don't want to or we can't live in dense areas. I have a disability that makes it difficult for me to be around a lot of density, a lot of activity, a lot of cars, a lot of bright lights and stuff. And I appreciate the Boulder County has had agricultural zoning, which protects that and has had that. Hannah has characterized this as a minor change in line with the comp plan and everything, but to some of us, this is not a minor change. I support ADUs for many purposes, like aging in place, caretakers, multi-generational families. I support ADUs in areas where they make sense, like the people from Marshall that we've heard from. Sounds like it's a great place for having ADUs. I would just like that the Planning Commission could take into account that not everywhere that was affected by the Marshall fire is the same, and the same rules which would help those people in Marshall would, in my mind, have a negative impact without some kind of review of the impact. If all of my neighbors that are rebuilding each put in an ADU, and I have no say on it, and they can put them up, then I have no options. So I just like you to keep that in mind. And that's all I have to say.
Thank you, Mr. Ellis. Andrew, do we have any other signups?
Yes, we have one more speaker, Molly McCrae. Molly, if you could state your address for the record.
So my name is Molly McCrae. My address is 5938 South Vale Road. I hadn't exactly planned on speaking today, so I'm a little bit unprepared. Two of the things I wanted to bring up were the previous regulation for ADUs that allowed ADUs for family care, as discussed, were limited at 700 square feet. But those were also considered, to the best of my knowledge, non-residential square footage. So once you add it as a disaster recovery unit, it is now counted against your residential square footage or your presumptive size max. So it penalizes us to not have family to care for. Mrs. Hipley had noted that maybe combo use of multiple locations or residences could work. And I'm just from my background, we're a family of four, me, my husband, and a 7-year-old and a 3-year-old. And the idea of fitting into 700 square feet, and our other option being that we, I don't know, make the kids sleep in the camper. I'm sorry, it's not funny, but it's very frustrating. The presumptive size max also, there's two issues when you're applying the presumptive size max. One is that they're taken from the outside measurements of the wall. In this case, if I do an energy efficient, fire resilient upgrade and my walls are a foot thick, I lose 1 square foot of interior living space per linear square foot of exterior space. And those are based on a platted subdivision, which only penalizes Marshall and South Vale. When Marshall looks up at Wildflower, we look down at Wildflower with gigantic homes and ranches. So calling it within character of the neighborhood is kind of a misnomer and unrealistic. And then the last thing, within the 50 square feet, we have just under 5 acres, and to put our ADU within 50 feet of our primary residence doesn't balance for the size of the property. And I think the amount of land and the size of property are not being taken into account for the size of the ADUs, the residential square footage, and the distances. Thank you for your time.
Thank you, Ms. McCray. Andrew, do we have anyone else signed up?
This is Andrew with CPNP staff. We have one person with their hand raised, Stephen Jacobs. I've promoted you to a panelist. If you would like to speak for this hearing, you are welcome to accept that invitation. We also have 2 people, David Farmer and Tabor Ward, who were signed up to speak previously, who I don't see still. If either of you are present, please either press *9 if you've called in on the phone, or enter something in the chat so I can promote you and you can speak as well. Thank you.
Thanks, Andrew. Mr. Jacobs, I see you're in the room. If you can unmute, and you can turn on your video if you'd like. I see that you're unmuted, but I'm not hearing you. Still not able to hear you, Mr. Jacobs. If you are attempting to speak. Still not able to hear you. I don't know if your computer or phone are on mute or something. Still not hearing any audio.
This is Andrew with CPNP staff. Mr. Jacobs, I'm going to try denoting you and promoting you again and to see if that helps. In the meantime, Mr. William Holland, I noticed your hand is up. You're welcome to speak if you would like.
Thank you. I would like to echo Steve Bouchon's comments. I'm the president of the Davison.
You could please state your name and address for the record, please.
William Howland, Box 990, Boulder, Colorado. I'm the president of the Davison Ditch Company, Davison Highline Lateral Ditch Company, and the South Boulder Canyon Ditch Company. 2 of those ditches were impacted by the fire. And our concern, as Steve has noted, is that dwellings, accessory dwellings, may be placed very close to the ditches. Probably this will result in quite a bit of confusion and heartache on the part of the homeowners and property owners who are trying to get this done. So I would just say that we would really appreciate any notification of structures that are going to go up within 50 feet of the center line, which is typically the setbacks that a building department in Boulder County applies on things. we understand that in some areas this may be very difficult, and we have allowed narrower setbacks, but that usually requires putting a ditch in a pipe or a box culvert. So if that is going to be something that is considered, we would ask that the applicants contact the ditch company well in advance to see if that kind of a application or infrastructure is possible. Thank you very much for your time.
Thank you, Mr. Howland. So, Mr. Jacobs, I see you have been promoted once again. If you can unmute yourself and give it another try. I don't see the unmuting happening. Andrew, do we have anyone else signed up to speak, or did the other members that did not?
This is Andrew Goldstein, CPMP staff. I don't believe we have anyone else signed up to speak. If there's anyone in the meeting who would like to sign up still, please put your name and address in the chat.
Okay, and Mr. Jacobs, it looks like we're having some technical difficulties getting you on audio. If you note in the chat, there are some email addresses that you can send your comments to. Okay, it doesn't sound like we have any other people signing up. Is that correct, Andrew?
This is Andrew, CPMP. No, I haven't seen any other messages.
Okay.
Excuse me, Chair.
Yeah.
Chair Bloomfield, this is Rick Hackett, CPMP staff. Stephen, Mr. Jacobs, if you can hear us, you might want to try leaving the meeting, quitting your Zoom application and rejoining. That may help above something that has occurred with your connection. If you want to give that a try, that's the only thing I can think of. Also, Kim Sanchez has put in the chat an email address you can send written comments to. So I just wanted to give Mr. Jacobs another moment to see if he can figure out his connection.
Okay. Looks like he has disappeared. I guess, Andrew, can you let us know if he reappears as having signed in again?
Yes, I'll keep my eye out.
I'm a little at a loss of what to do here, because this could take several minutes for him to get back on. And I don't want to close the public hearing. Oh, it looks like we have one other person who's maybe wanting to speak, Mr. Bosley.
Mr. Bosley, I've just sent you an invitation to be promoted. You have the floor.
If you could start with your name and address, please, for the record.
Yep. Hi, my name is Phil Bosley. Everyone calls me PJ. My address is 963 Paragon Drive. Our house was completely destroyed in the fire. I figure if we're waiting for the people to join, I can kill a few seconds. I have a family of 4. It's me, my wife, and 2 teenage kids and a dog. And there is no way we are going to be able to have a happy, healthy home in 700 square feet while we rebuild our house. I'm a little bit frustrated with the process here. I feel like there was a lot of hoopla around asking for feedback from the community, and it seems that the community overwhelmingly supports something larger, and it seems like that feedback is being ignored in the short term for the sake of the long-term state of the community, which really just doesn't help those of us that lost our homes. The 50-foot limit as well. On our property, we had a 900 square foot detached shop. I would love to rebuild that and turn that into an ADU. The edge of that shop is 52 feet from our house. The far edge is about 70 feet from our house. We wouldn't be able to reuse that either. So as these rules stand right now, they just don't help us. And that's pretty much the feedback I have.
Okay, thank you, Mr. Bosley. It looks like we have Mr. Jacobs back in the room. If you can unmute yourself and go ahead and speak. Okay, I'm still not seeing you. Oh, there we go. I see you unmuted now. Hopefully we can hear you.
Oh, you have me.
Yes, victory.
Thank you. I had to go to the iPad. My computer wasn't, the microphone wasn't working. I tried the iPad, so I'm glad I'm here. What I wanted to reflect on is
You can state your address for the record, please.
Yes, Steve Jacobs, 1588 Marshall Road. I also have two other addresses in Marshall, 1600 Marshall Road and 1590 Marshall Road. 1590 was a small cabin in Marshall and was totally destroyed. And I wanted, it was approximately 574 square feet. And I was told that I could only rebuild to that footprint size and was also obligated to have a fire suppression system in there, which would be another 100 square feet for the mechanical room, I would imagine. And expenses and costs are somewhere in the neighborhood of $400 a square foot to rebuild. And it just seems that having to do that would leave me with 600 square feet of usable space and really not economically feasible to ever recoup that kind of money, through a long-term rental. I just don't see how this solution really makes sense for me. Do you follow what I'm saying or have a comment on that?
We're just taking your comments right now. We're not responding to your comments. So we'll allow staff to respond if they have any response once we close the public hearing.
Okay, but being that the unit was only 574 square feet, I would like to think I could rebuild back to at least 700. I was given the impression that that might not be allowed. And I think realistically, to have to rebuild something like that, we should be looking at around 1,000 square feet for the expense involved with that type of rebuild. That's my comment.
Okay, thank you, Mr. Jacobs.
Thank you.
Okay, do we have anyone else signed up or any last minute takers? Again, if you're on the phone, I don't know if we have anybody on the phone, but you can raise your hand by pressing *9. Andrew, do you have anybody else signed up?
This is Andrew Goldstein, CPMP staff. No, I don't see any other signups right now.
Don't have any other signups. We'll go ahead and close the public hearing. Oh no, wait, sorry. Before we close the public hearing, we allow the staff to make clarifying statements. So Hannah, do you have any comments? You're muted, Hannah.
I guess I'm confused. Are we not closing the public hearing until after my comments?
I'm looking at the sheet that I have, and it says I think it says, oh, sorry, close the public hearing. Okay, we'll close public testimony and then we will hear your comments. So public testimony is now closed and we will allow staff to make any comments.
Thank you. I do have some comments. First of all, I want to clarify what may have been misunderstood. If someone had a legal second dwelling or a legal accessory dwelling, they can already rebuild that. If you have something that was not legally constructed, was not permitted, you would need to follow the land use code at this time. There was a comment, I think from Ellen Berry, about cisterns and water sources. And while I don't have an answer to her question, I think the comment raises a very real issue, is that development in Boulder County is constrained already because of lack of things like city water and sewer in many areas. Many people are on wells. They may have a cistern that they fill through the use of that well and then use that for their potable water. So that the code language that we have really differs to those utility providers to tell us if the water source is sufficient. For those folks who might fill a cistern from a well, that is the State Division of Water Resources. So that is a step someone would need to undertake in order to, working with the State Division of Water Resources or with perhaps the city of Lafayette. I believe they provide water service in the area, but they would need to work directly with those entities in order to provide to us that assurance that they do in fact have these basic public health requirements for people to live in a home. The ditch company comments I wanted to address real quickly. We did, through the adoption of Article 19, amend the zoning requirement down from 50 feet to 20 feet from the setback of the ditch. In places like Marshall, that 50-foot setback basically engulfed almost the entirety of many people's property. This does not, however, preclude or allow people to build in the easement. The ditch easement is going to still need to be respected regardless of what our zoning setback says. Again, I think this could be problematic in some areas where folks do need to be close to the ditch, or maybe their home was already pretty close to the ditch, because I don't know that that easement is clearly defined. Again, so homeowners are going to have to work directly with the ditch company to understand what that easement actually is. So it is not the intent of any of our regulations to infringe on ditch company easements. Let's see. There are a lot of comments about folks having families of 4 and not being able to live in 700 square feet. The accessory dwelling might not be the appropriate solution for those folks. There is a temporary dwelling unit that is already allowed in the land use code. It is not size limited. And we did add that to Article 19-500 so that folks did have a temporary option. Accessory dwellings are something that folks all over the county have an interest in. I'm sure you saw some of those comments in the letters that we should be doing this countywide right now. So while this first phase is to target early folks planning for rebuilding, it is not the only reason for the accessory dwelling update in general. The housing element that speaks to kind of consideration of accessory dwellings is really about housing. It's about providing affordable housing. It's about providing another choice in places where it can be supported. I think we touched on this earlier. We didn't do a whole lot of land use analysis, and kind of looking at transportation networks or impacts on transportation for this. And, you know, the resulting proposal is, it is relatively narrowly defined. You know, it reflects the fact that we didn't get a broad section of input from the community. A lot of our, the feedback that we did get was from Marshall Fire impacted folks who are supportive of these, which doesn't provides, you know, a specific snapshot of a certain group of folks. It's not a broad community perspective. And we do have to consider how these might work in the larger community in the long run. So let's see, a couple other comments. One thing I did want to point out, someone made the comment that they thought, you know, there was a penalty for rebuilding these in relationship to the residential floor area. And I just did want to clarify for folks that right now, the accessory dwelling units require a limited impact special review, which is a discretionary review of the use itself. And so that floor area currently may not be approved. It could be denied. The two types of accessory dwelling units that we have really, the agricultural accessory dwelling unit is not a residential use. That's accessory to an agricultural use. And then the historic accessory dwelling unit is intended to preserve an existing structure. So those sizes kind of reflect those specific types of uses. The 700 square foot that we do have for a family care unit, I think is somewhat consistent with what we see around, you know, our state and maybe around the, you know, in other states. At 700 square feet is what is in the family care unit. It's what we've proposed here. It's something that allows these to remain accessory. In California, the floor areas or square footages range from 850 to 1,000 square feet. Larimer County has a range from about 900 to 1,200 square feet. Jefferson County's range for these is 600 to 1,200. Summit County limits these to 1,000 square feet. The city of Golden's regulations limit them to 50% of the living space or 800 square feet. And the Routt County limit is also 800 square feet. So I think what's proposed at 700 square feet is consistent with kind of what we see for accessory dwellings. You know, and reflects kind of the challenge of doing kind of this expedited short-term or expedited kind of text amendment. You know, without the ability to do some in-depth analysis. Let's see, I just want to make sure I got all the comments I wanted to make. Okay, I do think that covers it. Thank you.
Okay, thank you, Hannah. Do we have any questions for Hannah before we go on to discussion?
This is Commissioner Gargano. I just wanted to clarify how you measure the square feet again. Like, is it, I read in the amendment, it's the usable floor space, right? It's not from the outer walls, like someone thought it might be.
So the way the regulations are drafted, it just limits the accessory dwelling to 700 square feet.
Okay, I thought I saw something about usable floor space.
Now, other jurisdictions, you know, might describe that differently, but it's very simple. It just says the accessory dwelling is limited to 700 square feet. You know, when we measure the area of a building for the purposes of defining residential floor area and those things, we do measure from the exterior of structures.
Okay. we have any other questions for Hannah?
I do. This is Commissioner Goldfarb. Hannah, when you were just giving the statistics on other counties, there were ranges in the sizes that you mentioned. How is the determination made as to what size of accessory dwelling unit someone could build?
It depends on the jurisdiction, but sometimes it's about lot size only. The Larimer County, let's see. In other cases, it's a combination of the type of unit, whether it's attached and detached, and the lot size. So it really depends.
Thank you.
Thanks, Anna. Kim, you have your hand up.
Yeah, commissioners, I just wanted to add one last comment to the responses. I wanted to respond to the comment of frustration about not listening to the community. I guess I just wanted to clarify that the community comments have been really helpful to us, and we've taken a lot of effort to meet with the community on several occasions to get input from them on first the Article 19-500 regulations in the first place, and then this addition. We're here today because we heard from them about the desire for accessory dwelling units. So that's one of the reasons why we're even contemplating this code change in the first place. We know we may not be capturing all of the things that people wanted with it, but this is a staff proposal, and now we go through the public process, and the public process is intended to have them provide comments to the decision makers, you and the Board of County Commissioners, so that we can consider the points that they're raising, the needs that they have, and see if the proposal should be modified at all. So, while this is the staff proposal, we're open to, consideration of the comments that come up. I definitely don't want those to be considered or construed as being dismissed, because the public has played a really important role in getting us to even where we are today.
Great, thanks, Kim. And
this is Commissioner Goldthorpe. Can I ask a follow-up question? There was mentioned one of the members of the public who spoke was concerned about the 700 square foot limitation for a family of 4. And I think, Hannah, you mentioned the temporary dwelling unit possibility in a situation like that. Could you just speak to that and how that might work, and how that, as I understand it, that can then become a permanent residence?
Well, I think 700 square feet of it could be in going forward, could be the accessory dwelling after the family of 4 was done using it. I don't know these particulars of this family, but perhaps if the way Article 19 is drafted right now, if you are building a temporary dwelling, it does require that you provide some plan, for what's going to happen to it after. And that's what we would hope folks who are taking advantage of this are able to consider. If long-term they don't need a full second home, and a home for a family of 4 is not really accessory in the long run. That's a second dwelling on a property. That's a multifamily use, which is not allowed in the zoning. So I think on an individual basis, we would need to work with property owners who are proposing a temporary dwelling to see how that does work in the long run. There could be a variety of iterations. Perhaps part of it is converted to another use. I really don't know.
Thank you.
thanks, Anna. Just to kind of clarify that, it sounds like what you're suggesting is someone could effectively build a 700-foot ADU and then maybe add a couple of bedrooms onto it that are somehow decommissioned later.
Or perhaps that part is converted to, like I said, a different use, but yes, it's no longer part of the accessory dwelling, and maybe it becomes the, you know, a garage portion or something else that the property owners could use in a different manner.
Great, thank you. Any other questions for Hannah?
Yeah, I have one. This is Commissioner McMillan. Hannah, I fully understand you may not have this answer at your fingertips, but do you have a sense of like how many square feet of buildable floor area some of these properties have? Like if they were to rebuild to the max of what they were allowed to rebuild with their single family home. I understand there's a range, you know, it may be as low as, you know, 2,500 in some cases and 10,000 in others, but like, what is the maximum that you think on average these homes could rebuild to? Sorry, that's like a lot of caveats to that question, but I'm trying to get a sense of like, if we were to implement a percentage and say like, hey, you can build 20% of your maximum floor area, like what number would we end up at? And it's hard to project that, I think.
Yeah, well, I mean, I think that's why when we draft those 30%, like that 30% language that I throw out there, you know, if we do some rough math in some of the neighborhoods where the size presumption is 7,500, you know, 30% of that is 2,250, which is a big home. So it's not really an accessory at that point. So I think that's why when we get into those percentages, we do have to have some sort of maximum.
Yeah, yeah, for sure.
You know, on a smaller property where, you know, say that in a neighborhood where the size presumption is, you know, 2,500, 30% of that is 750. So the range for what the size presumption is quite large.
Yeah, I understand that challenge. But in the case that you just mentioned, if you were to build that 700 square foot ADU, you would have 1,800 square feet left over for which to build your home. Is that right?
Correct.
Okay. Thanks.
Any other questions for Hannah? Okay, so hearing other questions, we'll go ahead and move into discussion. I do want to just take a moment to thank staff for all of their hard work, thank the public for all of their valuable input. We definitely know that this is a difficult time and difficult thing to kind of figure out what's the right balance here. So I just want to thank everybody for their input and for their hard work. I also just want to kind of broad context, you know, we're obviously talking about the Marshall fire, and that's what we need to focus on right now. I do think that there's some opportunity to, you know, give some comments for the longer term, the phase 2 of the ADU process. And so I would just kind of ask if we can try and separate those two out if we have a comment for that. And then my idea was that we basically go through, where did that go? It was, I had it pulled up and then I searched for something else. Basically there was, I think there were 9 items. It was sections I through X that seemed like or I through IX, excuse me. So page 8 of the packet, the subsection B detail requirements. My thought was that we basically go through those one by one and commissioners can make comments on each one of those, and that way staff can kind of have them all collected. Does that sound like a good plan to y'all?
This is Commissioner Fitch. My suggestion would be that we address the the size question first, because I think a number of things will derive from how we treat that and how we conceptualize what we're doing with the decisions that we make about that number.
Conveniently, that's item number 1, so.
Okay. So can I speak to that question?
Sure, let's just go ahead and yeah, so right now it says the accessory dwelling is limited to 700 square feet. So go ahead and speak away.
So I think I share the concerns that there are really different types of situations here that we're trying to consider. And I would actually put aside the question of phase 2, because I think there's some things that we might want to do for phase 1 that we would not want to do for the county as a whole. It seems to me that there's I think it would be better if we had really a 2-tier kind of process rather than a single process that has to apply to every ADU proposal that's in the Marshall fire victims category. When I bought my first house in Boulder, it was a townhouse in South Boulder that was 1,100 square feet. And there was no way a family of 4 was going to live in that. It was enough for me and my kids who were with me part of the year. But I think you've either got to make some possibilities or create a category that goes beyond 700 feet, say 700 to 1,000, or 700 to 1,200, whatever that ultimate number is. If you're going to try to provide a solution to people who are going to use this as a temporary dwelling while they spend 3 or more years building their replacement house. So I don't think the 700 square feet is going to deal with those people. I don't think that you can really adequately deal with, so you can't put the family of 4 in an RV. So there's some temporary structures already allowed for in the existing provisions, but those don't adequately serve the number of people who showed up in the written comments and some of the public testimony that are really looking for a place they could use as a temporary house while they rebuild their permanent house. So I guess my proposal would be that you have 2 categories. The first category would be basically something that is clearly accessory, 0 to 700, 750 feet, where you could say, yes, these could take care of the caretaker, the extended family, intergenerational kinds of uses. But if we're going to talk about really dealing with the situation of families who are going to use this ADU process, then we've got to have something bigger. And I don't have any magic numbers other than I think it's got to be at least 1,000 square feet. Maybe it's 1,200. And I think the choices that really remain for us is to either say we're not really trying to address those people. We have no solution for those problems for those people through the ADU process. If that's what you want to do, then I think you should approve the staff proposal. If you want to try to deal with this, with the family size dwellings, then it seems to me we've got to have a higher limit, but we definitely do want limits. I don't want to have people just building a second house, a new house, and then they build a second full house, 3,000, 5,000, 10,000 square feet to go on that lot. But it strikes me that we could do in that higher square foot category, we could grant some degree of flexibility in the height limit, especially if it's on top of a garage or something. Some flexibility in the 50-foot requirement, especially if it was a large lot that we're dealing with, that you could have a limited site plan review process done by staff with some kind of appeal process if necessary, where you could have more flexibility for what you would do within that maximum square foot by basically making your case on a site-by-site basis to the staff to say, no, we're going to meet the objectives of the comp plan and the land use code, but we need some flexibility to do it. So thank you.
So this is
Thanks, Ben.
Commissioner, oh, sorry.
Yeah, I'll just jump in with some comments. I think, I mean, what I heard Hannah say was kind of a little bit of what you're talking about, Sam. You know, we could do, if somebody wanted to build an accessory dwelling unit that was permanent and that didn't meet the needs of their family, then they have the temporary structure that's already, that piece of the code is already in place. And so they could basically add a couple of bedrooms. And then once their house is built, then they just need to convert that so that it's not a large second home, essentially. You know, so I do think that there is that flexibility using those two things, because otherwise they would have to decommission the entire temporary home, or there, you know, there have to be some other path. I think where I take issue with the 700 square feet is, you know, I don't think the comparison to a family care unit is a really appropriate one, because a family care unit typically is you're caring for an aging parent. They are going to be incorporated into the family, and so maybe they're using the living room, or they're, you know, they have a small kitchenette, but they're having dinner with family lots of times, that sort of thing. Whereas if we're talking about an ADU that's meant more for a care worker, or you know, a family member that maybe wants to have a little bit more separation, then I do think a larger size is appropriate. I also, I'll just say that I kind of, I bristle a little bit about the 30% reduction. It seems like that penalizes smaller homes, which just seems unnecessary to me. We have the maximum residential floor area that's allowed on the property. And, you know, maybe we have like a, I don't know, a 45 or 49% so that we can say that it is an accessory structure. But, you know, if somebody has a 1,000 square foot home and they can build 2,000 square feet on their property, I don't see why we should limit that ADU to 300 square feet. I mean, that's just, it's unusable. I have lots more comments, but I'll let some other people chime in. I know, Leisha, and I cut you off a little bit.
That's okay. You said some of the things I was going to say, right? That the temporary housing certainly addresses the issue for these people, for these families. So I just want to reiterate that point as well, right? Like, I do think there is a solution for them in that scenario. I wonder if 700 is too small if we're measuring from the outside. I just, it can be a pretty tight just space when I think about usability, if we're asking people to be, to have fire suppression and be environmentally friendly, that kind of thing. We have done in the past where it's like, maybe it's whichever is smaller, right? So it's 800 square feet or up to, right, or 30%, or 800 square feet, or to your point, saying if you have a 2,000 square foot permit and you want to do 1,100 and 900, right? Maybe it's maybe it's like 900 square feet or 45%, whichever is smaller, right? Something like that, so that you're not penalizing the smaller homes. You're still offering like a fairly usable size, something like that. So that's where my head's at right now, is like, could we do, maybe it's just a little bit bigger, right? And then it's still limited, so that if you've got a 10,000 square foot max, you're not building a 4,000 square foot ADU. The 50-foot distance, I think you might have touched on this or I feel like you said something about it, Mark, or I made it up, but there's a review process, right? We could create a special review option, or maybe it was you, Sam. There could be like, or if you want to be in the 50 to 100 range, staff can take a look, something like that. So that seems like another option, right? If 50 feet is too close for some folks, because we know from all the other things that we've heard, right? Nothing is ever going to work for everybody, right? There's always a dozen edge cases that we absolutely can't solve for unless we're physically on the property, taking a look at that individual property. I don't want to create too much work for staff, right? So it would have to be tight enough. And obviously not having to go to staff if you're within 50 feet would be a reason for people to consider that. So that's where I'm at, but I do think this is a great idea, and I do support it, but there's just a couple of things that we would probably want to change.
Hey, Chris, I see your hand up.
Yeah, first of all, echo the comments about, I really want to thank, staff for being super responsive to the community's feedback on this and getting a plan out so quickly. And also all the community for their feedback. It was super helpful for me, at least, to read through all the letters and see everyone's personal experiences and their objectives with what they're trying to rebuild. It really provided a lot of different points of view about what people's objectives are in this process. So thank you for all that. I did want to comment on that. Something I feel maybe is missed, and maybe it's because we're not clear on what the scope of that looks like, but multiple of these requirements do have the carve out for the director's limited site plan review waiver process. And just kind of knowing a lot of these areas and knowing how unique a lot of the different environments are, and lot sizes and particular historical uses and everything else that these communities had. Certainly, I hope that site plan review waivers can be an important part of this process, in terms of not necessarily needing everything to be, for the person who's 52 feet away, but it says 50, maybe, that's a good use case for a site plan review waiver, and hopefully that process isn't too burdensome. So I just wanted to point that out.
Chris, just a reminder to start your comments with, this is Planning Commissioner so-and-so.
Sorry, this is Planning Commissioner Whitney. Thank you for the reminder.
Yeah. David, your hand is up.
This is Planning Commissioner David Chu. I guess I'll say a few things. I think the 700 square feet is too low. It seems like it's based on an arbitrary comparison of a family care unit and is not supported by any other reasoning specific to this situation here, just disaster recovery. It seems like we should figure out what the goals are, and as I understand, one goal seems to be at least to have some housing for some people, maybe not all, not a family of 4, perhaps maybe not a family of 6, 7, certainly not that big, but that seems to be one goal. And then there's different goals in the comprehensive plan as far as looking at limited increases in density, innovation, accessory dwelling units, affordable housing. These were listed in the packet, and at least the 700 square feet doesn't seem to address anything but perhaps a limited increase in density. So I feel like that criterion has been overweighted at the expense of everything else. There's and you know, I can't remember the comprehensive plan by heart, but I'm sure there's questions about character and compatibility with the county. And what I'd like to say is that compatibility and character is really people dependent. And when you don't serve the people, the residents who've been displaced, that is not compatible with character or compatible, or it's not compatible with the character of the county. And so to further the goals of the comprehensive plan, we should try to accommodate both more of the displaced people, as well as the future inhabitants of Boulder County, which is also listed as a goal. I also want to say that I think, you know, some range to get to Mark's point, you know, if you have a really small house, you don't want to get penalized for it. So we could put a minimum, you know, 700, and then have the disjunctive phrase like 1,000 or 30%. I would also say that we should have that fraction or that percentage calculated based on the maximum available rather than this principal dwelling, which seems really strange since it doesn't exist. I also wanted to talk about this temporary housing unit. I think in theory, it is a possibility for people to have that, but in practice, I think it's really a tough situation. People are underinsured, people have to pay for building a new house. So these temporary units, even if you have a 700 square foot ADU, adding 2 temporary bedrooms costs money. And then with the intent to just destroy it later on seems like a lot to ask for someone to do who's struggling with a lot of things, like what, you know, how do I build this, not only my primary dwelling structure, but an ADU plus 2 bedrooms. That's a lot of logistical headaches for someone who's, you know, already under a lot of stress from this whole situation. I don't think that's a viable solution. I'd like to see the square footage go to at least 1,000. You know, I think it might not work for a family of 4. It could work better for 2, and I think, you know, most houses have at least 2 people in there. My first apartment, 1-bedroom apartment out of grad school, was 800 square feet, and that was good for 1, but 2 I think would get a little bit tight. And then, yeah, I think those are all the comments I have. Thanks.
Thank you, Commissioner Shu. Anne, I see your hand up.
Yeah, thank you. Couple of comments. It seems Hannah mentioned that we're doing this in an expedited fashion to respond to the Marshall Fire disaster. But my concern is that what we've heard from a number of the people is that we aren't being really responsive to them with either the temporary dwelling unit solution or the ADU solution in regard to size with the ADU solution. And I'm also concerned that we have so many different kinds of properties in the county. And again, I understand that we can't do something that's perfect for everyone, but my concern goes back to doing this in an expedited fashion. Again, I don't think it's responsive to people who've been affected by the fire. I think we need to look at this some more. I mean, people are talking about, you know, okay, I think we should do more square footage, or I think we should do something with a percentage. We've heard that Other places are doing things differently in terms of having a range, looking at size of the property, the lot, the size of the house. I just think there's so many variables here that trying to come up with this, 700 square foot, or even if it were 1,000 square feet, I just don't think that I don't think that we've thought it through well enough. And that to try and cobble something together at this point isn't going to do the people of the county justice. That's it.
And,
thanks.
Sam, you're up next. Sam.
Thank you. Thanks, Mark. Commissioner Libby. I'll just have a few short comments. People hit a lot of my points already. And I'm trying to focus on just the square footage topic as we're trying to go through somewhat sequentially. I'm certainly in support of a higher number. 1,000 or more seems good to me. And I think it sounds like many of us, as well as many of the folks that spoke, were. There are also, as Hannah stated, likely folks that are opposed to that who didn't have comment or didn't speak or weren't able to vote in that. But we do our best with the comments that we receive, and the tendency was clear from today. Also, Hannah shared the other municipalities or counties and their numbers. I have to note that the 700 square foot proposal was the only one that was as low as it was of all of those. So I know that our situation is different. This is under a disaster, not a countywide ruling, and that countywide rule may be forthcoming, but it is proposed as the lowest, which seems to support it being a little higher to be in conformance with those. And the last comment I had was, there's another ADU type that we haven't discussed as much, the agricultural worker unit, that does have an 1,800 square foot maximum. I think there's an assumption that's often on a larger property, as most farms are, but there is another somewhat arbitrary value, as we don't know the background on that, that is much higher than that. I'm not saying we should go that high, but there are other ADUs that are oriented towards families or maybe other groups of people that can fit in a larger space. And then last, to Anne, your point about not having maybe thought through it all the way. I try to remember that there is another hearing with the county commissioners. There's a chance for the staff to adjust both their presentation as well as the text for that hearing. There's also public comment in that hearing. People can reiterate their feelings or change their feelings in that commentary for the county commissioners, who will decide on that. So I think there's certainly a lot of feedback we've shared, and people are able to share again on that. So yeah, I'll just say I'm in favor of suggesting that number be increased in our approval of this staff recommendation if we go forward.
Thanks, Sam. Connor, you're up next.
Yeah, I'd like to start by just saying that I think that staff did a really good job of trying to come up with a solution that could appeal to a lot of the people in our area. And obviously, like we've said, there's no solution that's going to appeal to everyone. I think, first of all, that 700 square feet is a fitting size for an ADU. When I think about an ADU in the traditional sense, I think it doesn't change the nature of the area that it might be put into. I think it doesn't put as much stress on roads and transportation and population density. However, we have been phrasing it as we are making an effort to help with the rebuilding process post-disaster. And so because of that, obviously, we're getting kind of blurred between being accommodating to a family in need and also what might be a best practice for using ADUs in the future. For that reason, oh, and sorry, also just for reference, I don't have a family of 4, but my house is less than 1,000 square feet. So on the contrary, I can also see how people would balk at having a house, a full-size house, as an ADU in a backyard of maybe a neighbor's house. And so I guess what I'm trying to say is I'm in favor of increasing the number of the square feet limitations for this exact amendment. Up to 1,000 square feet is where I'm leaning towards personally. And I also just want to make a note that I think that not acting quickly in this regard is also a disservice to our citizens, because obviously we could spend a lot of time looking at available data and being really thorough. But if we don't make some movement on this, I think it's going to be worse than having a 700 square foot limit. So yeah, anyway, I'm just summarizing by saying that I would support going up to 1,000 square feet in this amendment. Thanks. And sorry, this is Commissioner Candidate, if I didn't say that at the beginning. Sorry, Mark.
We'll get it. Yeah, this is Commissioner Bloomfield. I think my proposal, and I see your hand up, Gavin, so I'm not gonna preempt you, but my proposal is that we kind of do a little straw poll on this topic so that we can move forward to the other topics and just kind of know that we're in agreement so that we're not getting all the way down the line and then we're rehashing the square footage, since it seems to be the most important topic here. And so I would say my rough proposal would be 1,000 square foot limit up to 45% of the maximum allowable floor residential floor area for the property. And then I feel like that gives a good balance between, you know, there are going to be some people that are able to do that. There are some people where they have a family of 4, that's probably still not enough, but maybe they add an extra bedroom that's temporary. And I feel like it's a good balance. And I definitely agree with what Connor said about the need to make a decision soon. I mean, Anne, I totally hear what you're saying about like, we need more study. I definitely feel like that's what phase 2 is for. And I feel like we need to be able to make a decision tonight. So, so before I do any kind of straw poll, Gavin, you have your hand up.
Yeah, Commissioner McMillan, I'll be brief. I also agree 700 square feet is too low. I think the goal within an ADU or an accessory dwelling unit is that it really needs to be subordinate to whatever the final home that is constructed on the site is. And the challenge I'm struggling with is that we don't have the final home on the site. So it's hard to make that relationship through policy right now. So I think what would make sense is again, to reiterate what Mark just said, is that we would set a percentage of the total allowable square footage that could be built, and whether it's 30% or 45% or 50%. I think that's a staff question that needs more analysis, but I think that percentage should be in there. And then I think there's a range. So there's a minimum that you can build, no questions asked. I would recommend 800 square feet. There's a maximum that you can build, I'll say 1,200 square feet. And then you put a percentage of the total buildable square footage. And this would help if you had a small buildable amount that, you know, 30% of it only allowed you to build a 500 square foot, you could still build that 800 square foot minimum. And if you had a huge lot that, say, you know, would allow you to build 10,000 square feet, you couldn't build a 3,000 square foot ADU. You'd be capped by the maximum of 1,200 square feet. So I like that kind of range and percentage approach. You know, if that's too complicated, I think 1,000 square feet could work. But that's just kind of where my head was going. So I don't know if that introduces another option, Mark, or if it's just a combination of all these things, but.
Yeah, I guess I'm curious as to what commissioners' thoughts are. For me, this is Commissioner Bloomfield again, the 1,200 square feet starts to get into like a separate home. I feel like 1,000 square feet allows you to have, you know, 2 bedrooms. You can have a couple living there comfortably, maybe even a couple with a kid, if they're a caregiver for the main dwelling unit, that sort of thing. I feel like 1,200 starts to get pretty big. And again, like I'm pretty sensitive to not just favoring large properties, because and I think the 1,000 square feet also strikes that balance between people who are like, we don't want to, you know, have, you know, the gentleman that said that, you know, 50% of his neighbors would be adding another house essentially. I think that kind of strikes the balance between the need for people to be able to build something that works and not have it be kind of just another house. So anybody else have any thoughts on that?
This is Commissioner Gargano. I think I'm kind of flexible on that. I'm with you, Mark. Like when we start to say 1,000, 1,200, that feels really big to me. So I'm still very much in the like, you know, 800 to 1,000 range. Also like you know, let's say if we picked 800 or 900, it's, you know, it just seems like pretty universally like fitting. If we do 1,000, maybe we have to do something like Gavin said. We already have those regulations, right? If your lot's this big, your house can be up to this. If your lot's giant, you max out, right? At 7,500. So we already have that grading system that could fit into that. But again, that feels like a phase 2 to me. Like I love that, but it feels not like an expedited decision. So part of me thinks we just pick a size, you know, and move forward now, knowing that for phase 2, we need obviously to think about it a lot deeper.
And I see your hand up.
Thank you. I just want to interject real quick while you're having this conversation about size. I just want to clarify that our neighborhood size presumptions are not based on lot size.
Right.
In fact, I don't know that there's anything in the county land use code that regulates based on lot size, in part because lot size isn't really a reflection of the developability of the lot. Larger lots can have more resources of concern that we actually need to look at. So
That was clumsy language on my part.
I just want to make sure we're all on the same page.
We are. I'm sorry.
Okay.
I meant just we have standards that set in place how big houses can be based on where you are and all the things. Yes.
And
yeah, if we're talking about, you know, coming up with a number for size, we've been talking about caretakers coming and living in this ADU. What I would ask people to consider too is the possibility that if you have an elderly couple who want somebody on the property to be caretakers, perhaps a family member, a son or daughter who has a family of their own, that they in fact may move into the primary residence, which is what I've heard people in my neighborhood talking about, that they would then move into an accessory dwelling unit. And so you would have 2 people. And I would echo what other people have said, is that 700 square foot caretaker unit presumes perhaps only 1 person living there. And I think that's too small. So I would definitely think that we need more than 700 square feet. And as to how we come up with that number or that percentage, that's where I'm struggling because of the diverse nature of the properties in the county that have been affected. And I also have to say that I'm concerned about doing something in this situation and then going into phase 2. I think there needs to be consistency between phase 1 and phase 2. I understand we have an emergent situation here, but I just think we have to be cognizant of that going forward, the consistency.
Thanks, Ann. Sam Fitch.
Commissioner Fitch, I'd like to say I agree with Gavin's approach. We have a square foot number, but also a percentage of the permitted square footage. That gives us a basis for talking about. And I think the question now is, do we want that maximum number to go from 7 to 1,000 or 7 to something other? I have no magic answer to that, so I'm willing to go along, but I think the combination conceptually works, and this, as Sam Libby said, gives staff something that they can chew over, look to see the pros and cons before it goes to the commissioners. But I do think we ought to move forward. I don't feel that we're bound. Anything that we do here today binds us to do the same thing exactly in phase 2. I think we've got an emergency situation for a fair number of county residents that we ought to try to address as best we can in the time that we have. So thanks.
Thanks, Sam. Chris?
Yeah, this is Commissioner Chris Whitney. And maybe this is point of clarification as well for staff, but my understanding of the presumptive size analysis is based on the neighboring houses. And in an area in which your neighboring houses may not be built yet or may not even have plans yet, like how does that affect the presumptive size analysis, or would we just be using the historical presumptive size?
Hannah, you're muted.
That's a great question. We have captured all the data from, that existed in the neighborhood from before the fire. And so we do know what the presumptive size maximum was for each property at that time. And so that is what we have been using. So I don't think having the right data would be a problem for us.
And then, sorry, Commissioner Whitney again. And then if my understanding the new section properly, there's a plus 25% bump that they can do as well. Is that correct?
Right. Article 19, while we're talking about size and, folks maybe needing or wanting a little bit more, already drafted into Article 19 is an allowance for people to expand up to 1,000 square feet or up to their size presumption, whichever is smaller, through our expedited review process. So that sort of growth is already built in. And then wherever this lands, pardon me, on the size factor, that would then fit in to that number that folks are allowed. What I'm hearing loosely though is that Planning Commission like to see the size number go up, but that's pretty clear. It seems like a combination of maybe what Commissioner McMillan proposed with, giving people a minimum at maybe 800 square feet with a maximum. I'm hearing a little bit less agreement on the maximum, maybe 1,000, maybe something a little bit bigger, but also including a percentage of that size presumption. And this does not need necessarily to be wordsmithed by you today. If that is the direction that you want to provide staff as far as what you would prefer an approach like that, we do have a little bit of time between now and the Board of County Commissioners to explore that and present sort of a different recommendations to the Board of County Commissioners. Thanks.
And can I ask you to just put your hand down just for cleanliness? Okay, so I guess I'm okay with the if we just do a straw poll of Gavin, I think you said 800 to 1,000 square feet, and essentially the sliding scale of that is based on your maximum. So your minimum is 800 square feet. You go up to 1,000 if your maximum floor area allows for it. Is that what you were saying?
Yeah, I had suggested 1,200.
Oh, right.
I would be open to, well, if we all want to come to an agreement on the square footage number, great. Maybe we won't be able to. I don't know. I'd also be open to just saying, hey, this is kind of the range we're thinking of, and like to have a percentage and let staff dive into the data and figure out correctly. If there's a consensus that 1,200 is too much, I mean, I understand. I'm not going to fall on my sword for that number, but it just seemed like a nice upper limit to me. But it's on the table.
Okay, Commissioner Libby.
Yes, Commissioner Libby, just to clarify, we said minimum. I think you're just saying there's a range of maximums, not that you have to build something of a certain size, right? Okay, so a range of maximum sizes. I'm really happy with how Hannah positioned it, as the feedback has been received and they're happy to look at it. I don't believe in wordsmithing it up for us at this time. I think the two things we talked about is an increase, and then some idea that increase should be limited in terms of the overall consumption of space on the property, so that the ADU is not larger than the original home or proposed home. And that seems like it's been clear. If we're all good with that.
Okay, yeah, then I feel good moving forward with our next thing if everybody is in basic agreement with that. All right, thanks everybody, and thanks for that, for helping us out there, Hannah.
I might have to go back and listen to what I said again, but I think I got it.
Okay, so part 2 was the floor area shall be considered residential floor area and fit within the size allowance provided. And so I mean, does anybody have any comment on that? Okay. Then we'll keep rolling. Primary dwelling, short-term rentals, secondary short-term rentals, and vacation rentals shall not be permitted on the property with an accessory dwelling. I certainly have a comment on that. I wholeheartedly agree that the ADU should not be allowed to be a short-term rental unit. We're not trying to create a market for Airbnbs here. We're really looking at supporting either the primary residence, or allowing for a little more affordable housing. I do think that the principle, and I'll say also, I should caveat this whole thing with, I don't feel super strong about this for the Marshall Fire disaster recovery units. But since it's in here, I just want to make this statement more for phase 2, because I don't think it's actually going to become an issue with the disaster dwelling units or disaster recovery units before we actually get to phase 2, but hopefully that's the case. I just want to say, the reason that was given restricted to restricting the primary dwelling unit was to prevent further intensification of the use, but the use is not actually further intensified by a short-term dwelling use. In other words, if it's your primary house and you go out of town and you want to rent it to supplement your income, I think that really aids with the affordability piece. We can look at affordability from how much does it cost to build or buy, and then also how can you supplement the income to make it more affordable. And just I think that should be guided by the short-term rental piece of the code, because the short-term rental code actually limits it to the number of parking spaces that you can have is actually much more limiting to the use. So it's potentially at the use of the single family dwelling or less than that. So again, that's a little bit more for phase 2, but I just wanted to make that comment. Does anybody else have any comments on this?
Yeah, this is Commissioner Candidate, and Mark, I think that you just put a lot of my thoughts into good wording. But yeah, just to clarify, because I know some of the letters that we received in the packet, there was some concerns about doing ADUs in phase 1 or possibly phase 2 because of increased like Airbnb usage. And so, yeah, I just want to say that I wholeheartedly agree with that this stays in the amendment as is. And obviously, there's just a lot of confusion about what ADUs can be used for. And I think that this really addresses a big concern. So thanks.
Any other comments? Okay. Moving along to 4. Accessory dwelling shall use the same access point and driveway as the principal residence. Any comments on that?
Commissioner Libby, I had one that I meant to ask earlier, but I'll just make a comment here for staff. There was some text in there about submitting a transportation plan, et cetera, as part of the overall building permit for that new structure. I assume that would encompass this driveway and they could make changes or proposals as part of that for this. Otherwise, I think it makes sense.
Thank you, Sam. Next is one on-site parking space must be provided for the ADU. Any comments on that?
Commissioner Libya, I do have a comment on this as well. This is already actually listed in the definition of accessory dwellings in the land use code in G.3. So I just propose that we not include it again in 19-500 as it just adds to it.
Is there a reason, this is Commissioner Gargano, Hannah, is there any reason we would want to keep it in both places?
Just give me a moment to look. If you don't mind.
Yeah, it's 4-516 G.3.
I think you're right. No.
Cool.
So we can take that out.
And we don't have to like write it down that you're taking out. We just tell staff that they
I
know.
think this is all feedback. Yeah.
Yeah, they just know to do it
and
before the next
you could
meeting.
choose not to. That's just my feedback. Yeah.
It's just redundant.
Yeah.
I mean, sometimes it's helpful to have, regulations all in the same place for people so they know what's going to apply to them, but it's not necessary, but I can at least make the language align.
Okay. Thanks, Hannah. And thanks, Sam. Looking through the, 7 through 9, does anybody have any comments on any of those? They seem fairly straightforward and hopefully uncontroversial.
This is Commissioner Gargano. I mean, those are required not just by us, right? But that's like those are health and safety and like state. We can't get around those.
Again, you are correct. The State Division of Water Resources is going to regulate regardless of what we put in our land use code. I think this makes it clarifies to the public that this is, that they need to do this and that these things need to be provided to us at the time that they apply. So.
Okay. Chris, I see.
Commissioner McMillan. Oh, I'm sorry. There's some hands up. Go ahead. Those with hands up.
Chris, go ahead.
I guess I'll go ahead. So not directly related to any of these, but while we're kind of talking about 9, I don't know how to address this, but this is Commissioner Winnie. One overall maybe concern I have, especially because in some sense, some of the situation we have with some of this rebuilding effort is because we're rebuilding structures that are not necessarily allowed under the current land use code, is how do we prevent a situation in which, say, if one of these structures is destroyed after 2027, that they can rebuild it as they rebuilt it after the fire again, in the super unfortunate situation in which that happens. Because if
that question.
Yeah, sure.
So if something is a legal non-conforming use, which these would be, if they don't kind of meet the long-term outcome of phase 2, legal non-conforming uses are able to be rebuilt after disasters. I don't know if you recall, but we made some pretty specific amendments to the non-conforming uses in Article 19-500 because we do have a significant amount of non-conformity that we wanted folks to be able to rebuild. So typically, if you have a legal use destroyed by disaster, it can be rebuilt.
Commissioner Rennie, yeah, thank you. I just wanted to make sure that was covered just in case our phase 2 plans didn't quite align with what we're doing here.
It's certainly not covered here, but it is covered in the non-conforming section of the land use code already.
Okay. Commissioner Hsu?
This is Commissioner Hsu. Unfortunately, I booked an international client meeting in 8 minutes, so I'm going to have to log off soon. But I think you guys know my views. I just wanted to put in one extra point, which is you guys will probably talk about later, but the 20-foot height limit, I guess I would subject that to the site plan review waiver in addition to the 50-foot footprint one. That's all.
All right.
Yeah, this is Commissioner Gargano. I liked, Sam brought it up before too, like if someone wants to build something above a garage, for instance, right? To be able to, oh, Hannah had something to say about that.
Yeah, I have a question about that, but
Then
he's gonna answer it.
I think there's a little bit maybe of misunderstanding. The 20-foot height limit only applies to a detached, standalone, separate accessory structure. It doesn't apply to those that are kind of going up above your garage or attached to your studio, your pool house or whatnot. So it's only limited for the one type.
Okay, so Gargano, I was considering a detached garage a detached unit, but you're saying that's not the case.
So that would be the second unit where it's attached to an accessory structure, because these, the way this works is the size is set up so it's relatively small. So if you put a 700 square foot unit above, as a second floor above a garage, that's going to be 1,400 square feet. So the lower level garage is not going to be part of the accessory dwelling. It's going to be accessory to the principal house. So it is a little confusing for sure.
I appreciate the clarity.
Okay. So I feel like we've covered 1 through 9. Does anybody else have any other sort of general comments?
Commissioner Libby, I want to reiterate one thing, which was just some clarifying language around the 50-foot setback. I think that was clear, but I'll have people know what they can do. That's all I had.
Okay, Chris.
This is Commissioner Whitney. One more kind of general line number 1 or A, I guess, comment. We talked a little bit about, or we had some questions around damage versus destroyed. And I was just kind of curious if we wanted to revisit some of that conversation here as well.
Yeah, that's actually, I'm glad you brought that up. Before we launch into that, or maybe we just launch into that. I don't know, Gavin, I see your hand up. Did you have anything quick before we get into that whole?
Commissioner McMillan, I had the same point about the damaged or destroyed. I do think maybe on the 50-foot rule, a little bit of guidance might be helpful, because I think there's a big disparity between it has to start within 50 feet or the whole thing has to be within 50 feet. I mean, that could be a 100-foot swing depending on how we think that should be. Right. So, for me, I would say like maybe the entirety of the structure needs to be within 100 feet or 75 feet might be the way to write it. Otherwise, within 100 feet of the closest point of the primary structure.
Can we say 50 feet for the closest point of the accessory structure to the closest point of the?
Maybe that's a suggestion instead of wordsmith. This is
I don't want to
we have Hannah look into that.
I think like for me, it could be within 100 feet. The entirety of the structure could be within 100 feet of the house, and that would be fine. However you want to write that, I think is up to you. But I think for the whole thing to be within 50 feet is too tight. Is my thought.
Fair enough. Commissioner Rainey, did you have anything else that you wanted to add in terms of the partially damaged? I mean, I think we can open that discussion for sure. I guess, Hannah, one question that I had was, are there any like staff reasons that were restricting who can rebuild some of these things? In other words, like if we just open the floodgates, then like we want to have, the people, obviously, I think the people who have their primary structure is gone. We're prioritizing them so they have a place to live. And then it definitely seems like there are some people that fall in this gray area where their primary structure is perhaps only smoke damaged. And so, but it still has the same impact of them not being able to live there for 2 years.
I mean, there's always sort of, anytime we adopt new regulations that are going to generate development, it has staff impacts. You know, those who had their homes destroyed do have staff, you know, a dedicated rebuilding coordinator. You know, folks who didn't, you know, depending on how wide sort of this door is opened, it's, you know, the staff impacts vary. But yes, I do think there are always going to be staff impacts, both at, you know, at planners, at the building permit counter, our inspectors, you know, it all rolls downhill. And I don't know if then are we prioritizing kind of these reviews and potential site plan review waivers for just the folks that had their house destroyed, or it was spoke damaged, or so yeah, those changes, depending on what they are have implications.
So I guess my question is, Commissioner Bloomfield, we have a definition of destroyed. Do we have a definition of uninhabitable? Could we say like destroyed or uninhabitable?
Well, that is one thing. I think we could look at the definition in that section, for instance, or the way that language is written. Right now, it says a single accessory dwelling may be constructed when the principal single family dwelling was destroyed by the fire. We could say sort of as determined by our damage assessment process. So that would clarify the question that was asked before, like how were these decided to, you know, how did we determine which were damaged? You know, you could, if you wanted to add that, or rendered uninhabitable. That's a little, I'm not sure exactly how we, at this point, without exploring that more, how we know what uninhabitable means. It's something I'd probably like to talk to the chief building official about, but
Okay.
we can
You
explore
feel
that.
like, is that good enough guidance for you?
I think so.
And are we in agreement on that? I don't want to just throw that out there.
Gavin isn't sure.
No, I agree. I would just say, this is Commissioner McMillan, I would just say that I think the goal is to make it easy for you, Hannah, and your staff and the public to know that they are eligible or not eligible. And right now it's a little unclear to me.
Got it. Did you have any other comments, Gavin, or was that your hand raised? Okay. Do we have any other comments? Okay. I do have one more comment that's a little bit more phase 2-ish. And it's a little outside, but I do want to just kind of have it for staff, hopefully as guidance, because it's stuff that hasn't really been addressed. So one is just that, you know, staff did an excellent staff presentation about land use code and its impact on racism and economic discrimination. I'd also extend that a lot, and I think this question of ADU and how we use our houses is a discrimination against those who have non-traditional family structures, because there are pretty severe limits on how they can use their houses versus someone who has a family and they can have a lot more people in those houses. So I just ask staff, as they're looking at the ADU, the phase 2, beyond this Marshall fire relief question, that they really include the mitigation of all of those types of discrimination in their considerations. And also, one thing that will become important when we're looking at this phase 2 is I'd request that staff look at some flexibility for any existing homes that want to do an ADU within the existing envelope. Obviously, that's not relevant for the fire victims here. But I do think that having some flexibility allows the county to perhaps meet its goal of minimizing resource use, and also allowing a part of an ADU or a part of a home to be converted into an ADU. So those are my quick comments. Does anybody else have anything?
This is Commissioner Gargano. I just want to say I agree with that so much, and reminding us of that presentation and what we learned there, that right, that when we think about things like neighborhood character and all of that kind of stuff, that if we can consider those impacts, right, and the historic nature of planning as it is, just in the context of those presentations, I think it really helps a lot for us and for the public hearing it.
Chris.
Yeah, Commissioner Whitney. I also want to echo that, and although it's, you know, this is targeted very much at fire recovery, but it's also somewhat of a fortunate coincidence in terms of our plans for ADUs that this area of areas in Boulder County, a lot of these lots are bikeable to 36 and McCaslin Transit Center. They're, you know, bikeable for someone who is maybe a graduate student and wants to get into CU. And so of the areas in Boulder County where perhaps it fits with our comprehensive plan to be a little bit more aggressive with ADU development, certainly this area, in my opinion, is a good candidate for that. And so maybe compared to other areas in Boulder County that are further from transit or further from areas of employment, this particular area suits that a little better than maybe some other areas in Boulder County. And so I think, although this is motivated by fire rebuilding efforts, it also makes sense in terms of maybe longer term plans for what areas of Boulder County make sense for ADUs.
Okay.
We propose something before we lose Sam.
Yeah, that's what I was gonna propose. Does anybody have a motion? I mean, does anybody else have any other comments, or do we feel like we are good for a motion?
I'm happy to make a motion. I know we're going to be talking a lot about this in the next few months, I'm sure, or next year. So there's plenty more to discuss. And I'm going to move that the Planning Commission approve and recommend the Board of County Commissioners approval of docket DC-22-003 land use code text amendments related to the accessory dwellings, with the addition of the comments and recommendations we made during the recording today.
Commissioner Fitch, second.
Great. So somebody have a comment? So we'll do a roll call. Commissioner Bloomfield, aye. Sam Fitch.
Aye.
Ann Goldfarb.
Aye.
Sam Libby.
Aye.
Gavin McMillan.
Aye.
I think David's already gone. Connor Kennedy.
Aye.
Chris Whitney.
Aye.
And Leishan Gargano.
Aye.
All right, passes unanimously. Thanks, everybody, for that thoughtful consideration and working that out. Thanks to Hannah for great presentation, and again, for all the hard work. Does staff have any other comments before we adjourn?
I do not have any other comments, just to extend that thanks right back to you all. We appreciate your time and your thoughtfulness and the guidance that you give to us to hopefully help us get to a better outcome.
Yes, that is hopefully the goal. All right, do I have a motion to adjourn?
Move we adjourn, Commissioner McMillan.
Okay, everybody in agreement, say aye.
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 Thank
Aye.
you.
Aye.
Good
I
night.
think that's everybody. All right, thanks, everybody. Y'all have a good night.
Bye.
Aye.